All right, while the jury walks into that courtroom, let's talk about this ruling from Judge Cannoni with criminal defense attorney Jeffrey Wolf. Jeffrey, thanks so much for being on with us from Denver, Colorado. Let's talk about these slides. So the slides are out, and just to tell our viewers, if they've been watching the arguments, Dr. Rentschler is expected to testify, or the defense wanted him to testify, that the abrasions on John O'Keefe's arm matched up with the different holes in his sweatshirt. And he has slides to this effect with text on it. Hank Brennan said he's not a fabrics expert. He shouldn't be able to get into that. Your thoughts on whether we have to have that kind of expertise on every level when he is generally a biomechanic and accident reconstructionist?
Well, when you're an accident reconstructionist, you have the ability to see what happens in an accident and observe it. And so that means he's seen people with all kinds of injuries and he's seen what happens to their clothing. So no, he doesn't need to be an expert in fabrics to know whether a tear on somebody's clothing matches up with the injuries he sees underneath. That is, quite frankly, proper lay opinion to know whether a tear matches up with a cut underneath it and whether that can be seen with the naked eye. And so I think that what we're seeing here is more of what we've seen throughout this trial, which is an exercise in how much can we keep away from this jury and how much can we obscure from their ears and their eyes. That is what the prosecution has been doing throughout this trial and what the judge has helped them do. And so it's crazy, quite frankly, to watch it continue to happen and to say that experts don't regularly use PowerPoints to illustrate their points and put things up in text form while they're talking. It's regularly used in trials. It's 2025. PowerPoints are commonplace for experts and lawyers all the time. It's just insane what we're watching happen in this courtroom.
Yeah, Jeffrey, I really wonder if the jurors feel uncomfortable about what they may not be seeing, because there are times like today when the forensic pathologist wanted to talk about dog bites and there was a sidebar. So I think sometimes jurors' ears perk up more when there's an objection where they can't hear what the subject matter is. Stand by, Jeffrey. We know that the jury has returned from their lunch break, so let's go back in for more of the cross-examination of that pathologist, Dr. Elizabeth La Posada. Let's hit the pause button on her testimony so we can talk to criminal defense attorney Jeffrey Wolf, who's watching along with us. She says it's a scratch, not a cut. Jeffrey, is that terminology important?
It is important because when you're talking about a scratch, not a cut, you're talking about something that's more superficial. And I think that when she defines it as a scratch, not a cut, she's not talking necessarily towards the prosecution's theory of a car, which is going to cut through the body. But what she's also doing is she's speaking in terms of maybe this, maybe that, whereas the prosecution thinks what they're doing is they're getting away from the defense theory of the case, where she was saying it's what the defense wants her to say it is. But what she's now doing as a good expert, quite frankly, for the defense is she's saying it could basically be anything. And if it could be anything, well, that's reasonable doubt. Because if it's not necessarily for sure a car that caused these injuries, well, it could be anything. And if it could be anything, that's reasonable doubt.
Yeah, I think something that she said earlier goes to your point, where she said, I don't know what caused it, but I know what didn't cause it. And that could be the banner of this defense case, because this time around especially, they're not telling this jury anything about exactly what happened, which they don't have to prove it legally, but they are saying it absolutely didn't happen this way. Is that effective in front of a jury? Do they need that question answered by the defense?
Well, I think what the defense has learned about the prosecution from the first trial is that the prosecution doesn't have all the answers. And when the prosecution doesn't have all of the answers, sometimes what you need to show to the jury is that the absence of proof is reasonable doubt. And I think that's the strategy that we're seeing this second time around from the defense here, is they are pointing out the holes in the prosecution's case rather than trying to answer all the questions and fill out that grand conspiracy that they tried to do in the first case. And I think it's a good strategy, and I think it's a better strategy, quite frankly, than they did the first time.
We'll see what the outcome is. We are getting so close to this case being passed to the jury. We're getting to the end of the defense case, and then we expect there to be a rebuttal by the state. and then closing arguments. It's coming soon, Jeffrey. Thank you for your analysis this hour. Coming up, we have more testimony in the murder retrial for Karen Reed. We have more of La Posada on the stand, and we're getting closer to hearing from the second ARCA witness, the accident reconstructionist, Dr. Andrew Rentschler. Thank you for being with us. We'll be right back.